Civil rights lawyer Randolph McLaughlin, CNN politics commentator Errol Lewis, CNN legal analyst Elliot Williams. Gentlemen, thank you all for joining us at the table on a really consequential morning in America because, as Phil and I were saying at the top of the show, this is a different America. This follows overturning Roe versus Wade. This follows the Bruin decision on guns, which totally changed the reading of the Second Amendment. And now this. What does this mean?
Honestly, I think step back for a moment, and it's not. When we look at the impact of Donald Trump's presidency, this is what the lasting legacy of the Trump presidency will be. It's not the wall, it's not the tax cuts, it's not any other thing. Both former President Trump and Senate leadership in the form of Leader McConnell made remaking the federal or reshaping the federal judiciary a huge priority. And abortion, for instance, and affirmative action have long been targets of allies of the former president. It's just a fact. And what you're seeing now are the impacts of that will persist for generations. I think we in America get caught up on the sort of day-to-day little political fights, and some of those will come and go. But judges remain on courts for their lifetimes, and this. Mark it down now. You're going to keep seeing decisions like this over the next 20 years because that's how the judiciary works.
Randolph, what's been interesting to me, having followed some of the conservative legal movement for a number of years, this has certainly been a goal. This has certainly been something they pushed towards. And I think when you have the 6-3 majority that Elliot's talking about, the real legacy, I think, of the Trump administration, there was an expectation that this ruling was coming to some degree. One of the individuals who was involved in the process of trying to get these courts in front of the case, in front of the court, spoke to our Kate Baldwin yesterday. I want you to listen to what he had to say.
But what do you say to the millions of people who point to affirmative action, race-based admissions, as a reason for their success in life?
I could point to race-based admissions as the reason why Asian Americans are being discriminated against right now. I mean, if you're an Asian American, you had to score 273 points higher on the SAT to have the same chance of admission as a black person to Harvard. Is that fair? I understand that people's lives are improved by getting into an Ivy League university, but that opportunity should be made available to people of every race, not just one.
What's your response to that?
My response to that is very straightforward. Affirmative action programs should not discriminate or penalize any racial group, whether they're Asians or other racial groups. That's categorically true. Should not. And the courts basically recognize that. But here's what I'm here also to say. Affirmative action is not dead. It's mortally wounded. That this court didn't go as far as they were planning to go, certainly in Justice Thomas's mind. Justice Thomas wanted to overrule and declare affirmative action completely illegal and unconstitutional. This court was unwilling to go that far. There is not yet a majority to say affirmative action is unconstitutional. There's a small group, Justice Alito, Justice Thomas, and maybe a couple of others who would agree with that. But there's still a window open in this case. There's still an opportunity. Diversity is still a compelling state interest. All the judges, except for Thomas, who has his own issues with this, all the judges agreed that that is still a compelling state interest. The only thing that was decided here categorically was that these two programs weren't constitutionally sound. That's all.
So that's indicative of the Roberts Court moving incrementally instead of in a sweeping way. But Laura Coates, let me bring you into this conversation as well, because the way that Justice Sotomayor sees that in this scathing dissent, in her words, is lipstick on a pig.
Well, it's really a realization that she has had and talked about over the course of her career, which is interesting, just juxtaposition between herself, of course, and Justice Thomas. One seeing it as racial sensitivity, one seeing it as racial paternalism. But this is all supposed to be rooted not in one's philosophical ideology, but instead based on the Constitution and also the context surrounding it. Remember, the 14th Amendment is a post-Civil War amendment intended to course correct those who have been disadvantaged, those who have been discriminated against, Black people in America, that has also been, of course, expanded to include other racial groups as time has continued. But you saw in the dissent, as you saw in the concurring opinion of Justice Thomas, the conversation really about what the intention of that was supposed to be in the long term. Now, of course, Thomas spent about 10 plus pages going after not only the dissent generally, but also Ketanji Brown Jackson, the youngest of the Supreme Court justices, of course, in her career. But he focused instead on the idea of a racialized ideology driving her particular perspective, as opposed to looking at what the Constitution, what the actual intent was, and beyond it. But what we saw here really, and I heard your prior guest talking about what the really conundrum can be and how this will work in practice, that's really the crux of, I think, the next frontier of arguments here. How do you, on the one hand, say that you cannot consider race as a factor, and on the other hand, have a sentence that says you can have a student or an applicant discuss such things in a way that talks about their identity, their lived experience, their journey? What is an admissions officer to truly do to not offend the Constitution, according to the holding, and not also avoid future litigation? I think this is going to be a really difficult task.
Yeah, really difficult task with, I think, a lot of litigation to come without any question. Errol, I want to ask you, Laura noted the dissent from Justice Ketanji Brown Jackson. It was quite visceral to some degree, and obviously very personal for her. And at one point she says, with let them eat cake obliviousness today, the majority pulls the ripcord and announces colorblindness for all by legal fiat, by deeming race irrelevant in law, does not make it so in life.
Yeah, that's really what the dissent was about. Justice Sotomayor made the same point, and for all of us who are sort of affirmative action babies, meaning we came in under this regime and got a shot at elite learning and a chance to really succeed in society because of it, Ketanji Brown Jackson is certainly one of those people. And if you look at the way things were, I mean, she's a realist, basically, when it comes to this. At Harvard, Harvard started in the 1600s. It's much older than the United States. For 300 plus years, they typically allowed into the college 12 or fewer black students prior to 1970, less than 1%. And all of that changed when affirmative action was created. And the minute it happens, it gives rise to this extraordinary group of people who go on to run major corporations. You know, they're running Merrill Lynch and they're running, American Express. Merck. Yeah, and then right behind that, you get the cohort in the 1990s with a guy named Barack Obama, and Ketanji Brown Jackson. And so does Sonia Sotomayor talks about this really as well, saying like, this is what it was intended to do. This is why it's not just something that's irrelevant, as Justice Thomas seemed to insist that it might be.
To your point, it also, we have to remember there was a day when Justice Clarence Thomas was an advocate for affirmative action. He has talked openly about how it was one of the things that propelled him into Yale Law School. Then he became very critical of what it meant for him and others after. What I'd like to do is play two pieces of sound. The first is Sonia Sotomayor in 1994, talking about being, in her words, an affirmative action baby. The next is Justice Clarence Thomas speaking to 60 Minutes in 2007 about viewing it in a diametrically opposed way. Here they are.
I am a product of affirmative action. I am the perfect affirmative action baby. My test scores were not comparable to that of my colleagues at Princeton or Yale. But if we had gone through the traditional numbers route of those institutions, it would have been highly questionable whether I would have been accepted.
Honestly believed that Yale thought that having a kid who came from working people in the South, who had grown up through segregation, that this kid who'd prospered, who'd done well every single place he'd ever been, whether in all-white school, all-black schools, he'd always done well, he will do well here, and it will benefit both him and Yale. That's what I thought. Now, that's what you do when you're 21, 22 years of age. You could make a mistake. Well, that isn't what it was converted to.
What was it converted to?
It was converted to, well, you're here because you're black. That degree meant one thing for whites and another thing for blacks.
It was discounted.
It was discounted. That's right.
You write in the book that your Yale degree was worth 15 cents.
Well, Steve, I have still a 15-cent sticker on the frame that my law degree's in. It's tainted, so I just leave it in the basement.
because he had a hard time getting a job after, even with that degree.
Unfortunately, Justice Thomas has not left his personal feelings and animosity towards Yale, towards affirmative action in the basement. He's put it right in front and center. He's made his personal issues, the stigmatic harm that he feels, he's made that a constitutional question. And I'm sorry, Justice Thomas obviously has an issue with affirmative action, but we should not allow one judge to determine what our national constitutional policies are.
6.
Well, yes, but he's the one who wants to overturn Grutter. The others don't yet. And you're right, incremental change is Roberts' hallmark. So just like Dobbs eventually overturned Roe, we may eventually see Grutter and Bakke also overturned. So the question is, what are we going to do about it today and now going forward?
You know, it's interesting watching those two clips next to each other because I think it affirms this idea that there's a lot of different ways to be a black person or a person of color, whatever it might be, in America. And they both have completely plausible reasoning for what they took away from affirmative action. I'm not going to quibble with either of them. The point with Justice Thomas, though, is that there is a demonstrable impact on admissions when you take affirmative action away. And so, by way of example, if you restrict or limit or sort of reduce the number of black people who come to a university, you're significantly limiting the number of women as well, because about 2/3 of black people in college today are young women. And so you're going to have to contend with some of these real impacts on changing the face, pun intended, of a future student body. And I just think even setting aside the personal views of whether affirmative action is stigmatizing or harmful or whatever it might be, it's going to have an impact on what universities look like starting next year or the year after.
Laura?
You know, it's interesting because on the one hand, people might forget that Justice Thomas was once the chair of the Equal Opportunity Commission, which is interesting to think about. Equal Employment Opportunity Commission, thinking about the history and really the evolution that he seems to have had. But I want to be clear on one thing. Everyone who's talking about affirmative action, I think the conversation has happened across the nation. Here's what it is and here's what it's not. Affirmative action is not one door for black and brown applicants, and then you decide whether they're qualified. It often is used in the admissions process that otherwise qualified applicants who have met the criteria, albeit subjectively, as a violinist, a cellist, a veteran, a legacy, somebody who is an athlete, a whole host of circumstances. And then there is oftentimes the contemplation of what might distinguish one student from another to contribute to the overall community. That's normally how it's viewed and used in operations and admissions. I'm hearing a lot of conversation throughout the last 24 hours about, finally you'll have students with merit who actually attend. Well, that was always the case. They also just happen to have different colored skin. Number two, when you're talking about the Brown versus Board of Education, think back to that infamous Dolls experiment that spoke to the sociological and psychological impact of racism and segregation. Part of what motivated that Supreme Court was that there was a test that had black children handed dolls that were black, handed dolls that were white, and they asked them, what did they think about the characteristics of those dolls? Black children looked at these black dolls and overwhelmingly thought they were bad, they were wrong, they were evil, they were ignorant, they were dumb. And that was what motivated the courts to say, hold on, racism has a psychological impact as well on white students as well who were viewing the same criteria. So conversations from Justice Thomas and beyond about the impact of race in America is still very much at issue today, given his own holding about the impact of affirmative action he believes on himself.
Everyone stay with us. There's a lot more to talk about here, really about